So Ms. Davis, let's not ever do that again. Let's never do that again. Ma'am, let's not ever do that again, including right now. So here's the first thing. We are going to only unmute when asked to do so by the court. Number two, the baby can't come to court. The baby can't come to court. Baby can't come to court. So
Yes,
ma'am,
ma'am,
let me say this to you. Do not unmute yourself again and talk to me like I'm some random stranger on the street, because it will not work out good for you. Now, I don't know why you just chose to do that, but let me be clear. As I am indicating, we are in court. If you cannot attend court because there's too much going on at your house, I'm in the building facility. And then I need to contact, what's funny? It's funny. Unmute yourself. What's funny? Unmute yourself. What's funny? What's funny?
I wasn't laughing, I was doing like this.
No, you weren't.
I was, ma'am.
In 56 years, I know what laughing looks like.
I wasn't laughing, man. Why would I be laughing? This is serious.
That's what I was thinking. In my mind, I was thinking, but what I do know is the difference between laughing and wiping your face. Ladies, please start your video. Miss Davis, you're gonna have to probably put on a jacket, but hold on, please. Miss Wilson, you got that camera real up close to you, but if you're not properly attired for court, you need to put on a jacket too. All right, I'm gonna put you in the waiting room. Your lawyer is not present yet. But while you're in the waiting room, please put on a jacket or change your top. This is, your lawyer is Mr. Werbling. Okay, so I'm gonna put you back in the waiting room, Miss Wilson. Miss Davis, I'm gonna put you in the breakout room, and a lawyer will be in to speak with you shortly, okay?
Okay, Your Honor.
Please remain in the breakout room until the lawyer comes in to talk with you.
Okay, and then I can go put the.
No, you can put the jacket on while you're waiting for them to come in.
Okay, this is a dress. It's a dress.
Oh, okay.
Yeah, okay.
Oh, okay. All right, well, I'm ready on Miss Davis, who wanted to say whatever she was saying. So let me assist Miss Davis. So Miss Davis, let's not ever do that again. Let's never do that again. Ma'am, let's not ever do that again, including right now. So here's the first thing. We are going to only unmute when asked to do so by the court. Number two, the baby can't come to court. The baby can't come to court. Baby can't come to court. Number three, don't log in laying down, whether it's on a couch, in a chair, or whatever. So let me be clear. We're in court, and we're going to present as though we are in court. Otherwise, you have to physically come to court. So if we can't sit up straight, as if we're standing up straight at that podium, then you can't attend court on Zoom. Then you have to come and stand at the podium. So
Yes,
let me say this to you. Do not unmute yourself again and talk to me like I'm some random stranger on the street, because it will not work out good for you. Now, I don't know why you just chose to do that, but let me be clear. As I am indicating, we are in court. If you cannot attend court because there's too much going on at your house, I'm in the building. I'm at 36th District Court. The building is open for all defendants who have matters pending before the court. So you're going to talk to me like I am the judge presiding, not like some person that you just met on the street or whomever. I don't know. But I'm giving you the instructions for how to attend court. They are the instructions for everyone who comes here. If you don't want to follow them, I don't know what to tell you. Now, I'm sure that in the beginning I said, I need everyone to remain seated, stationary, in an upright position, and ready to attend court. This is case number 164609001. The people of the state of Michigan versus Crystal Davis. The defendant is charged with 1 count of malicious destruction of a building, 1 count of assault or assault and battery. And today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Crystal Davis. Ms. Davis, ma'am, please unmute and tell the judge your full name.
Good morning, Your Honor. Crystal Davis.
Today is the date set for a final pretrial conference. How are we proceeding?
Your Honor, on behalf of Ms. Davis, Your Honor, I'm not certain whether the complainant was required to be present today. If that is the case, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter? You're muted, Ms. Ritter.
Sorry, Judge. My note says that there was an arraignment on the bench warrant on May 1st of this year, and a final pretrial conference was set for today, but I don't have any notes that the court required the complainant witness to be present, so I will defer to the court.
Not if it was an arraignment on the bench warrant, I didn't. So,
Okay.
I mean, again, I don't have my notes, but that wouldn't, generally I would not have.
Okay.
And it's at 9:04. That means that your client has failed to appear probably more than once, and then I set it for 9:04, which would have meant a high bond if she didn't appear today.
Okay, so Judge, could we set up, I know it's a 2016 case. I don't know. I know that there were some efforts at an alternative dispute resolution when the case initially came about. We have an indication that that alternative dispute resolution has been complied with. And it was back in 2017, but Ms. Davis did not provide proof of that to the court. Could we have the matter reset for final pretrial conference to determine whether or not actually requiring the complainant's presence, and if the complainant is present, giving us an opportunity to still do the alternative dispute resolution?
So in 2017, that would have been under Giles or King. No,
Yes.
it could have been under Archer. Who I don't know who was the judge back then.
I thought it was King.
That seems like it wasn't King.
But it may have been Judge Archer. I don't have the ROA in front of me right now.
Did she used to do alternative dispute?
Yes, Your Honor. The register of actions did reflect that should anger management be completed, that there would be a dismissal. And
the anger management might not have worked. Because she's
understood,
acting
Judge.
angry today.
So I have the certificate from 2017, but again.
Okay. I mean, I'll honor it, but I'm telling you, she acting angry today. So if Miss Ritter can look at her notes or whatever, and I mean, if that was the agreement back then, I suppose we'll honor it today, but okay, all I can say is I'll honor it today, but she might need to go to Mr. Rice's class. Is that certificate from Mr. Rice?
It's not, Your
I
Honor.
know it's not, because if it was, she probably wouldn't have been acting like this today. Okay, Miss Ritter, I want you to look at your notes. Ms. Stevenson says she has a copy of the certificate. The register reflects, that they were engaged in this alternative dispute resolution, and then she had a case dismissed. So if that's what the register reflects, or if that's what the notes reflect, maybe I also need to look at the actual file in the courtroom. Actually, Ms. Rutter, do you have the handwritten ROA where the judge writes on the file?
Give me one moment, let me check, Your Honor.
Yeah, check and see if you have that. Let me see what the judge wrote. If the judge wrote something, that's when we were definitely writing in the files back then. And then Ms. Ritter, you can also try to contact your witness. So I will adjourn the final pretrial conference. But if that was the agreement, like I said, I will honor it if she does have that proof. Let's set a final pretrial conference for that trial is really going off my docket. Let's do August 21st for the final pretrial at 9:04. And let's let me write this down. Proof of anger management and confirmation of agreement. Okay. So that's what I need that day. And I know we could, I was trying to see if I could do it sooner, but every day says no more, no more, no more. So I'm all booked up.
Okay.
All right. Well, unless we do it on one of those, I don't even see where we're doing any afternoons. No, because of that trial. Yeah, I'm booked up because of that trial. So that's it. Anything further then with respect to this?
Not from the people, Judge. Thank you.
Nothing on behalf of Ms. Davis. Thank you, Your Honor.
All right, then we're all set, Ms. Davis, until August 21st at 9:04. Have a great day. Stay safe. You're welcome.
Thank you, Your Honor.
You're welcome.
Your Honor.
He didn't. Mr. Hardwick, state your name.
Kevin Lamont Hardwick Jr.
All right. Today is the date Mr. Hardwick has been brought before the before the court on a tether violation. It says that he was found to be outside of his curfew, as well as to have a low battery on the tether. Additionally, there's some information that indicates to the court that Mr. Hardwick is without a home, has some mental health issues, and maybe on drugs. Court is inclined, based upon the report from the tether unit, to tether Mr. Hardwick to a drug rehab facility. Is there anything on behalf of the people or Mr. Hardwick with respect to the court's intention?
Nothing on behalf of the people, Judge.
No objection on behalf of Mr. Hardwick, Your Honor.
All right, then the court is going to tether Mr. Hardwick. The tether conditions remain. The only thing that's going to change is the location of his tether. He is not going to be tethered to the place that he was tethered to. And Mr. Hardwick can only be released to a rehab facility. And then I need to contact, what's funny? It's funny. Unmute yourself. What's funny? Unmute yourself. What's funny? Hold on, it won't let you. Hold on. What's funny?
I wasn't laughing, I was doing like this.
No, you weren't.
I was, man.
In 56 years, I know what
I
laughing looks
swear,
like.
I wasn't laughing, man. Why would I be laughing? This is serious.
That's what I was thinking. In my mind, I was thinking, but what I do know is the difference between laughing and wiping your face.
I wasn't laughing, man.
Yeah, okay. I didn't get all the way this far to not know the difference between laughing and wiping your face.
Wasn't laughing, man.
Okay.
I be having seizures.
Yeah, okay. Well, you wasn't having a seizure just now.
I know. I wasn't
Yeah, I
laughing.
know. So then it wasn't no reason to bring up seizures. Nobody's on here having seizures right now. Court is going to tether Mr. Hardwick to where was the place last when I was there was an issue with Judge Cobb's order, and they were saying they don't take women. I mean, they didn't take women, and Judge Cobb was trying to tether the person to Team Wellness, Team Jefferson. It was Team Wellness. So I'm going to tether Mr. Hardwick to Team Wellness. As a condition of his bond. When is his next court date? Ms. Rudder?
August 21st at 8:30.
All right. And then he'll be back before me for pre-trial August the 21st. Anything further?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Hardwick. Thank you, Your Honor.
All right, Mr. Hardwick, you're all set. They're gonna get you a tether and get you a bed at Team Wellness.
Thank you, man.
You're welcome. Have a great day. Stay safe.
You too.
Thank you.
Yes, ma'am.
Start your video, Mr. Morris.
Okay.
Mr. Morris, take the do-rag off your head. And then I'm gonna say, and your braids all together. Why you got on? Y'all just be coming on do-rags for no reason.
No, because I was, yeah.
Because aren't you trying to look good for a live Zoom as opposed? What you saving the hairstyle for? Don't answer. Just think, yeah, okay. Go to the breakout room, Mr. Morris. Go to the breakout room. Breakout room number 2. All right, I'm ready on Morris and then Patterson. Mr. Morris, turn your camera back on. All right. Morris and then Patterson. And Ms. Stevenson, you all are confused me with that height of designation, but I'll get to it in a minute. This is case number. This is the second person y'all letting come to court with a t-shirt on. The students are going to have to tell them to change their clothes. This is case number here it is. Case number 145509101. The people of the state of Michigan versus Davon Lawrence Morris. Defendant is charged with 1 count of driving while license suspended, revoked, denied. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the
Ronnie Melka appearing on the behalf of the defendant, Devon Morris, who consents to my appearance. Is that correct, Mr. Morris?
Yes, ma'am.
Can you please state your name for the record?
Davon Morris, Deontay Morris.
What does that mean? What does that mean? He said Davon Morris, Deontay Morris. What does that mean?
No, I said Davon Lawrence, Deontay Morris.
Oh, okay. Thank you. Because I'm saying you had 2 names. Okay, so your name is Davon Lawrence Deontay Morris.
Yes, ma'am.
Okay, thank you. Today is the day set for an arraignment on a bench warrant. What did Mr. Morris capious from, please?
Mr. Morris capious on May 12th, 2017.
From?
From missing a court date.
Counsel. No. Question is, what did he capious from? I know he capious from a court date. Was it a pretrial? Was it an arraignment?
Oh, it was
Was
a
it a final
pretrial.
Okay. Well, we'll continue. Now, here's the thing. Mr. Morris, in 2017, I think I was doing, I don't know what docket I was on in 2017. I don't know. I know I wasn't on this one. Now, let me tell you something about these misdemeanors for my docket. Setting up a meeting with the chief of police. I'm asking the chief of police for a warrant fugitive arrest team for the misdemeanor docket. We're not going to wait for you for how many years that's been. We're not going to wait for you this time. You need to come to court, okay?
Okay.
So I don't want to keep doing these old cases, okay? Because people get new cases. My docket is too full, and then the people come on here fussing at me because I can't give them a court date in 2 weeks and 3 weeks. Okay, so I'm gonna give you this court date. I want you to show up and write down the right date.
Okay.
Okay. When is your court date?
August 24th at 8:35
Okay.
a.m.
All right, Mr. Morris. He like, I got it, Judge. And then don't come on here with that do-rag on, because which one you think look better, the do-rag or your hair?
My hair. I'm sorry.
I know, exactly. Okay. All right. Anything further with respect to Mr. Morris?
Nothing further.
Miss Ritter?
I'm sorry, Judge, nothing from the people.
Okay. Miss, I'm here by myself all the time. Have a great day, Mr. Morris. Stay safe.
All right. Thank you, too.
You're welcome. I'm ready on Patterson.